I think most, if not all of you know who I am, Michael Byrne. I'm a judge of the District Court. I'm involved as chair of the steering committee for the expert evidence panel program team. Can I adopt everything that the Chief Judge had said in terms of the recognition of those who are present? Also recognise that we have Deputy Chief Magistrate Gett, who will be speaking, I understand, on a topic that's not part of my ballywick, but nonetheless welcome, Anthony. So in terms of this evening's contribution, I'm going to speak about the relevant recommendations made by the Women's Safety Justice Task Force, hear her voice, report to the legislative response to the recommendations, which include changes directly related to the second stream of the expert evidence panel operations. Courtney Arndell is the Director of Evidence Services. She'll provide a refresher on the stream one of the panel's operations, and Kate Phillips is the Program Manager, as well as Adelaide Smith, the Panel Liaison Officer, and they'll both take us through the pilot project itself, dealing more with the nuts and bolts mechanics, outlining the requirements, eligibility and program operations in a little more detail. If I can keep this moving sufficiently quickly, we should have a little time at the end for some questions and answers, so I'll attempt to do that. Now, I trust most, if not all of you, are aware that the Sexual Offence Expert Evidence Panel, I'm just going to refer to it as the Expert Evidence Panel, it's a mouthful otherwise. It's being piloted in specific locations, namely in Brisbane and Townsville. There's two streams of qualified experts who comprise the panel and who are able to give evidence in sexual offence proceedings. Stream one provides panel experts to testify as to the defendant's cognitive and mental health impairment at the time of the alleged offence and its impact on their ability to check that they have informed consent. Stream two is different. It enables experts to be appointed to give evidence about the nature of sexual offences and the factors that might affect the behaviour of complainants. The panel commenced operation on 3 February this year. That's when Stream 1 commenced. Stream 2 commenced recently on the 20th of September. That's why I'm giving this presentation today, because it's still so new. The pilot is a 2-year pilot program, and as happens with these things, there'll be an evaluation and decision as to whether it continues. Can I make this point straight away, though? That the panel is only part of the legislative response that has been undertaken. The provisions, whether it relates to Stream 1 and the cognitive ability to ensure that consent has been obtained, as well as Stream 2, the ability to lead specific types of evidence, applies across the state. But it's a pilot in those two centres simply to ascertain the ability, perhaps the desirability, of providing experts at no charge to the party who calls them. Now, this pilot is being overseen by a steering committee. I'm the chair. It also comprises members of the profession, including the ODPP, Legal Aid Queensland, the Law Society, the Bar Association, ATSLS, Women's Legal Service, the Office of Victims Commissioner, the First Nations Justice Office, and a whole range of other government entities. So quickly on the background, I don't want to spend too much time on this, seeing as I'm assuming you all have some understanding of it. The Hear Her Voice Report 2 recommended the establishment of this panel. The two recommendations directly relevant are numbered 43 and 80. 43 talking about the amendments to introduce affirmative consent, changes to mistake of fact, and the safeguard provision, as it has been called. Recommendation proposed that the Department of Justice establish the panel for sexual offence proceedings that can be used by prosecution, defence and the court. You see there on that slide that there is different reasoning for the different functioning of the panel. Stream 1 involves the task force and the former government implementing the relevant legislative provisions. It was concerned with not unfairly disadvantaging people with cognitive or mental health impairment to enable them to access a defence under the new affirmative consent laws. Stream 2 is entirely different. It is designed to provide participants in the criminal justice system, and that includes jurors, with a greater understanding of sexual offending. When the bill was introduced into Parliament, the then Attorney General indicated that counterintuitive evidence was not intended to be used to reason it is more likely the victim survivor is telling the truth or that the offence is more likely to have occurred. Rather, the purpose of the evidence will be to assist the jury in reaching their decision in an informed way, dispelling myths, stereotypes or assumptions about victim-survivor behaviour. As a lawyer, can I say there is a very fine line to be drawn between it going to the actual complainant and setting a context for decision-making. The type of evidence that the Stream 2 panel experts would be expected to be able to provide is evidence about the nature of sexual offences, the social, psychological and cultural factors that may affect the behaviour of a complainant in sexual offence proceedings. The provisions enable the calling of counterintuitive expert evidence for sexual violence proceedings in this state. They are based on provisions in Victoria. There are very much, not entirely the same provisions in New South Wales, but effectively the same. And New Zealand has been using this on a common law basis since the first case I know of was 2009. So this isn't all that new, really. Now, the evidence which might be sought from panel experts under Stream 2 may relate to the certain behaviour that might be misinterpreted. For example, continuing a relationship with an accused after the alleged offending occurs, any delay in making the complaint, the retraction of a complaint, the responses to non-consensual sexual activity, freezing, staying silent, that sort of thing. The evidence might also, in an appropriate case, address the impact of trauma on memory and the ability to recall at all or in substantially similar terms on multiple occasions. It may also address the development and behaviour of victims who have been the victim of sexual offending. Interstate experience, and notably from Victoria, has seen evidence called which speaks to the failure of the complainant to complain or yell out when others were nearby, of maintaining the ongoing relationship with the accused or continuing to show affection towards the accused after the alleged sexual offending has occurred. It may also address issues of delay or the timing of disclosure. Counterintuitive evidence requested from an expert is expected to be directed at potential behaviours that might be in dispute between the parties. Now, if the evidence or if the style of behaviours is not in dispute between the parties, there is a real issue as to whether the evidence can be called, that is, whether it's relevant if it's not in dispute. As I've tried to touch on briefly, the expert evidence is intended to be adduced in a general sense and not be specific to the complainant. It's said to serve an educative function, assisting the jury to understand that certain behaviours may be common among people who experience sexual violence. Now, these provisions that commenced on the 20th of September are in addition to the earlier enacted jury directions relating to sexual offending under Parts 6A and 6B of the Evidence Act. I won't go through them. I'm sure that you're all well aware of what I'm speaking about. The amending legislation, unfortunately, does not roll off the tongue. It's the Criminal Justice Legislation, Sexual Violence and Other Matters Amendment Act of 2024. It allows the leading of counterintuitive expert evidence, including but not solely from the panel, for a proceeding for an offence charged against chapters 22 or 32 of the Criminal Code, broadly speaking, all sexual offending. The relevant provisions commenced on 20 September 2025, but the transitional provision at section 176 of the Evidence Act now means that it only applies to offences where the originating step was taken on or after 20 September 2025. So summons, notice to appear, arrest. My mind wonders what's going to happen if there's been a warrant issued. Is the warrant the originating, an arrest warrant, I mean, by police, is that the originating step or not? One day we'll find out, no doubt. You'll all be aware that there is a rule that is not generally known in Queensland as the credibility rule, but that's how it's referred to in the legislation. You cannot adduce, in the absence of direct dispute anyway, you cannot adduce evidence to buffer the complainant's credibility, and I'm putting preliminary complaint evidence to one side. It's a recognised exception. But you cannot adduce evidence to buffer the credibility of the complainant, and that is only subject to direct attack, and even then not necessarily so. The new provision, section 103 ZZGC, has abolished what it calls the credibility rule. Now, given this is drafted from the Victorian provisions, one can only assume that's the rule they're talking about, because if you look through the definitions which haven't been transposed into the Evidence Act in Queensland, that's precisely the rule it's referring to. To be admissible, the expert opinion evidence has to be based wholly or substantially on the expert's knowledge. The court must be satisfied that the evidence could substantially affect the assessment of the credibility of the witness, and as a third and separate step, the court must give leave. There is some jurisprudence, not a lot, from Victoria saying that that is a separate standing discretion. So whilst the tendering party would need to satisfy the first two steps, there's still a discretion to get past. The Act also, at section 103 ZZGD, has abolished the rule that evidence is inadmissible if it goes to the ultimate issue or is a matter of common knowledge. So the evidence can still be led even if it goes to the ultimate issue. There is a dichotomy there, though, if it's going to be generalised evidence as to how it could go to the final issue or the ultimate issue. It would need to go directly to explaining that complainant's conduct in those particular circumstances. And the authorities tend to suggest it must be at a greater level of generality. The experts on the panel can be utilised by the prosecution, the defence, or can be called by the court on the court's own motion. Can only, however, occur in pilot locations. They will give evidence about the nature of the sexual offences and, as I say, social, psychological, cultural factors and the like. The pilot locations for Stream 2 evidence are the Supreme and District Courts in Brisbane and Townsville, as well as the Children's Courts in Brisbane and Townsville, and the Magistrates Courts by regulation in Brisbane, Caboolture, Cleveland, Redcliffe and Townsville. Because this evidence can be led at the committal stage, the parties should give early consideration when running committal hearings in those centres to calling the evidence at the committal to avoid delays, particularly under the timetable set under the Sexual Violence List program in Brisbane and Ipswich, but also more generally. It will also avoid unnecessary basher hearings in the higher courts. You may, if you come along wanting a basher hearing, have to answer why you hadn't done something about it in the Magistrates Court. It perhaps goes without saying, but because I've never been accused of being subtle before, experts from the panel are free of charge. At least to the parties anyway, not to the government. Even in the pilot program areas, privately engaged experts can be called. You don't have to use an expert from the panel even if you're in a pilot location, but there is the attraction of the cost benefit. Now, the court, as I say, can of its own motion engage or call an expert. There are a whole range of disclosure issues. I'll just simply leave it at that generality, disclosure issues to consider whether the court would do that, how reports are disclosed, whole range of things I won't bother you with at the moment. There is no ability, however, for the court to engage an expert in locations other than panel pilot locations, at least at this stage. Now, Stream 1 experts had their own disclosure or notice requirement. Courtney will talk to you about that shortly. For Stream 2 experts, it is Section 590 capital B of the Criminal Code, which in effect requires that notice be given to the other side of the intended expert evidence as soon as practicable. The usual requirements as to the name of the expert and the finding or opinion that may be given apply equally, and as usual, really needs to be done before the commencement of the trial date. There are the usual issues involved with that. That's a brief and perhaps a little rushed overview of Stream 2. Can I just pause to emphasise this? The authorities from Victoria, there is one out of the High Court from New South Wales, speak clearly of the need for generality rather than an expert testifying as to why this complainant did X, Y, Z. It is a need to speak broadly as to recognised behaviours. If any of you are interested, have a look at the High Court decision from 2024 in BQ and the King, and you'll immediately see there is a very fine division between the type of evidence that can properly be given, the generalised evidence, and the evidence that should not be given, which goes directly to the specific complainant and the specific circumstances. The Victorian cases have grappled with this as well. They've reached the same view for what it's worth. And there's also one of them, which is called Jacobs, which a pseudonym, and I think it's the Queen, I think it was before Her Majesty passed, around about 2019, 2020, spoke about the need for relevance to be defined by the issues in cross-examination. So if Defence Counsel limit their cross-examination which is not always going to be possible to do. But if they're able to and do limit it, it may preclude the ability of the prosecution to call the evidence at all. Anyway, that's a brief overview of Stream 2. I'll now ask Courtney to come up and talk to you about Stream 1 and a bit of a refresher on that.
Thank you, Judge Byrne, and good evening, everyone. As you'll no doubt be aware, the Criminal Law, Coercive Control and Affirmative Consent and Other Legislation Amendment Act 2024, sorry, I'll just change slides. That Act introduced an affirmative model of consent in Queensland and established a complementary legislative framework for the expert evidence panel to support those changes. Affirmative consent laws, which commenced on the 23rd of September 2024, emphasise communication between the parties to a sexual interaction, with consent now requiring free and voluntary discussion and agreement from both parties to take part in that sexual activity. An accused person can no longer rely on a defence that they had an honest and reasonable but mistaken belief that a complainant was consenting if they fail to say or do anything to ascertain whether the complainant consented to the sexual act. However, new section 348 A subsection 4 of the Criminal Code provides that the requirement to say or do anything to ascertain consent does not apply where the defendant had a cognitive or mental health impairment at the time of the sexual act, and the impairment was a substantial cause of the defendant not saying or doing anything. This is known as the Affirmative Consent Safeguard Provision, and Stream 1 operations of the panel support this safeguard. In establishing the safeguard provision, a defendant is legislatively required to adduce evidence from an expert, including a panel expert, to prove that impairment. A defendant who then establishes the safeguard provision may then rely on the mistake of fact defence. So a party may engage an expert from the panel to give evidence in a proceeding where the defendant's impairment is likely to be relevant to affirming consent, and the proceedings is before the Supreme District and Children's Court in Brisbane and Townsville. As previously indicated, Stream 1 operations commenced on the 3rd of February 2025. If you have a matter which may be eligible for referral, please feel free to contact the program team to discuss. And like Stream 2, a party in a pilot location is not precluded from privately engaging an expert that is not on the panel. Also, when parties outside pilot locations intend to rely on the safeguard provision, they will need to privately source and fund the expert as currently occurs. Should note there is a specific notice requirement for parties wishing to adduce Stream 1 expert evidence. Under Section 590BA of the Criminal Code, an accused person must give notice of their intention to adduce Stream 1 evidence within 14 days after they are committed to stand trial. Under this section, the notice must be in writing and given to the Director of Public Prosecutions. Now, if valid notice is not given, the accused person cannot adduce this type of expert evidence unless the court gives leave to do so. That's a quick refresher on Stream 1, and I'll now hand over to Kate, our Program Manager, to talk more about the pilot program itself.
Thank you, Courtney. The Sexual Offence Expert Evidence Panel pilot is intended to operate for 2 years, concluding on the 2nd of February 2027. The program team will be regularly monitoring the pilot during this 2-year period, using available quantitative data as well as feedback from requesting parties and other stakeholders. Feedback on our services and the processes that underpin them will be used to guide refinements to processes and procedures and will assist during any evaluation process. Further, whilst the Women's Safety and Justice Task Force recommended the establishment of the panel based on a similar recommendation of the Victoria Law Reform Commission, no such panel has been introduced in Victoria. Therefore, this is the first panel of its type in Australia, and we are mindful that the settings and processes we have in place might need to be tweaked as we operationalise both streams. To engage panel services, a party to a relevant proceeding must complete a referral form. Referral forms can be accessed on the Queensland Courts webpage. For Stream 2, the form looks like what you can see here on the screen and requires information regarding requesting parties, as well as information about the alleged offence, the location and court jurisdiction in which the offence is being heard, when the originating step, such as the arrest made or NTA took place, the name, age and cultural status of the complainant, the defendant's name, date of birth and cultural status, and identification of the type of counterintuitive expert evidence that is being requested. The referral form is in a PDF format and can be completed electronically or completed manually and scanned or posted for return to the program team. The form seeks various information about the defendant and complainant to facilitate the identification of any conflict of interest issues that might arise with the expert and render them an excluded person. The information in the referral form is intended to enable the program team to match the referral to an expert. Once notified of the details of the matched expert, it will be up to the requesting party to make contact with the expert. You can call or email the program team for assistance in completing the referral form at any time. Once the referral form has been completed by the requesting party, the following process will occur. The requesting party will receive an acknowledgement of receipt of the form. The program team will match an expert to the referral. For Stream 2, the program team will look at things such as the type of counterintuitive expert evidence requested, the complainant's information, relevant court dates, as well as things like the panel expert's availability, speciality and location. For Stream 1 matters, information about the defendant's potential impairments or disabilities, whether a diagnosis has been made, cultural information and offence type will also be considered. A letter of engagement will then be sent to the expert. The letter of engagement will canvass potential conflicts of interest. Once the program team receives the signed letter of engagement back from the expert, we will provide the requesting party with the contact details of the expert. It will then be up to the requesting party to contact the expert directly, give further instructions regarding the specific requirements of the report, provide relevant documentation and discuss any other aspects of the case. The expert will then prepare a report which will be sent directly to the requesting party, noting the program team will not have access to this. However, for quality assurance purposes, the program team may request de-identified reports from the expert. Under the scheme rules, up to a certain number of hours is funded, but additional hours may be worked and reimbursed with the permission of the program manager. Once this work is completed, the expert will apply for reimbursement from the program team. If required, the requesting party may call the expert to give evidence during a proceeding, and if so, they will be reimbursed for this work by the program team as well. The program team will liaise with the requesting parties to confirm work is completed prior to reimbursement. The Chief Executive, Department of Justice, or their delegate, is responsible for establishing and maintaining the panel under Section 103ZZH of the Evidence Act. To be accepted as an expert onto the panel, applicants were required to demonstrate the following in their applications: specialist knowledge, expertise and qualifications in assessing mental health and cognitive impairments for Stream 1, or concerning sexual offences and complainant behaviour for Stream 2. Evidence with the criminal justice system with a specific focus on providing expert evidence by way of comprehensive reports and witness testimony, demonstrated ability and experience in the application of trauma-informed practice, an understanding of how culture, race, ethnicity, age, disability, and other intersectionalities impact upon individuals and the community generally. All applicants were also required to undertake criminal history checks and are required to complete various mandatory training modules. At present, only 3 experts have been appointed to the panel. There is one in Brisbane, one interstate, and one in Townsville. They primarily have backgrounds in psychology. The program team has available to it a rolling recruitment process, which we hope will attract interest from more Stream 2 experts. We have done a mail out to professional organisations and practitioners who might have the necessary expertise. However, if you know or have worked with any experts who might be suitable and interested, please refer them to our website for further information about the rolling recruitment process. I should point out that experts are bound by a strict code of conduct, which is outlined in the panel's scheme rule and code of conduct document. This document is available for viewing on the panel's webpage of the Queensland Court's website. The code of conduct obligations include: the panel expert has a paramount duty to assist the court. The expert is not an advocate or party to a proceeding and must not accept or reject a particular opinion. The panel expert's duty to the court overrides any obligation the expert has to any party to a proceeding or the program team who is liable for the panel's expert fees or expenses. The panel must comply with an order made or a direction given by the court. It is a requirement that the expert on the panel provide an expert report to the requesting party directly and not via the program team. The expert report must include information such as the expert's qualifications and place of employment, all material facts, whether written or oral, on which the report is based, the expert's reason for each opinion expressed in the report, references to any literature or other material relied on by the expert to prepare the report, and reference to any matter the expert considers significant for the purposes of their evidence. I will now hand over to Adelaide to talk you through the roles and responsibilities of the panel.
The program team consists of Kate Phillips, the program manager, of whom you've just heard from, Trixie Martin, who isn't here today, but she's our intake administration officer, and myself, Adelaide Smith, in the role of panel liaison officer. Courtney Ardell, who spoke earlier, is the Director of Evidence Services, who oversees both the program team and the Queensland Intermediary Scheme. Requesting parties will firstly be in contact with Trixie, and thereafter I will be the primary contact for requesting parties and panel experts. I will also be responsible for the matching process. As the pilot progresses and demand requires, there is potential for team expansion with additional administration and liaison support. The program team is responsible for the recruitment and maintenance of the panel of experts in consultation with the Assistant Director General of the Supreme District and Land Court Service. The program team is responsible for the matching process and all administrative functions that underpin the panel, including the payment of invoices and organising any necessary travel for panel experts. It also acts as the secretariat for the steering committee. The program team is located on level 1 of the QE2 Courts of Law building and can be contacted by phone or email. Please feel free to reach out to us with any questions you may have once relevant matters start to hit your desks. As we've already indicated, the panel's webpage on the Queensland Court's website has a range of resources and information about the panel. This will be updated with further information and resources as the pilot progresses. For those of you who have colleagues in Townsville, we are holding an information session there next week on Thursday at 4 o'clock at the Townsville Courthouse. This will be solely focused on the panel pilot, and a link to register for this event can be found on the panel website. Before we turn to questions, we'd like to thank Judge Byrne for his oversight of the steering committee and his contributions today. It's greatly appreciated. And now I'll invite Courtney and Judge Byrne back to answer any questions you all might have about Stream 2 or the panel in general.
Are there any? Greg?
Assuming it's just general generality, why didn't the evidence be that the experts will be standing, all be saying the same things that are not much different from the great commitment direction?
Well, the entirely accurate answer is I'm not sure, but I won't be surprised if that's the case. And perhaps that becomes a basis for objection, although anecdotally, the practice, which is very much adopted interstate, is for an agreement between the parties as to certain propositions. Victims of sexual offending don't always complain at the first available opportunity. It's agreed between the parties. Takes out the issue, gets rid of the relevance of the evidence of the experts, so you get rid of the white jacket phenomenon. Anything else? Not that I'm trying to, I wasn't going to encourage anymore. Yes, Julie. Just a formal admission in the same way as any formal admission under section 644.
Even though it'll be general evidence, it must be evidence that will either make more probable or less probable a fact an issue about that complainant. If we're dealing with a sex trial with one complainant,
Yep.
play is an issue. Play might be an issue from a defence perspective for a forensic disadvantage. So you have to cross-examine to establish that, or it might come through the police officer or whatever. But how does it remain in one sense a general body of evidence that is not specific to the complainant, but the fact in issues are specific to the complainant that the jury need to determine? And the only reason this is in my mind is I was reading something recently that made me think about going back to basics with relevance. And one of the judgments I was reading was talking about making things obviously more or less probable, a fact an issue, or a fact about a fact an issue, making it more or less probable. It seems to me as though the only reason the jury would need to hear expert evidence about delay, and that not every complainant is homogenous, is because it would need to be relevant to that complainant. That
well, it needs to be relevant to the fact in issue in the trial. Yes.
Fact in issue is whether the complainant is telling truth, and maybe a peripheral fact in issue or something of that nature. And a peripheral fact in issue that might make that more or less probable is the delay. It must be that to explain that away, or there might be another side of cross-examination that establishes statistics, I guess, of somebody, if we know them, about the statistics of the number of people that do complain, relatively proximate to the alleged offence.
Can I say that earlier on I'd spoken of, from my perspective, there's a very fine line between the generality of the evidence and the specificity effect of the evidence. I didn't use those terms before. But to answer a question with a question, are we not well accustomed to now the receipt of evidence of prior acts of domestic violence being let in simply as context without going to proof? And it seems to me there's some analogy to be drawn between that and this type of evidence. I'll confess to not having done a whole heap of reading on this. as I say, anecdotally, I know that often it just gets admitted, formally admitted to, and then followed up by a direction. You only use it as context. That doesn't mean this complainant has been offended against because he or she didn't complain at the first opportunity. But it's to give you an understanding of, in my terms, the way the world works on occasions. But if you look at the Victorian authorities, there's MA and the Queen 2013 40 Victorian reports at 564. More recently, Woods, which is a pseudonym, and the Queen 2021 VSCA 105. They both emphasise the need for generality, as does the High Court decision in BQ and the King. Now, the one I couldn't find the case when I was speaking before, and I was right, it was 2019. It's a Victorian case of Jacobs, which is a pseudonym, and the Queen 2019 VSCA 285. It's the one that talks about a need for relevance. And I'm not sure which of the judges it was. The court was presided over by Justices Priest, Kay and Kennedy. And this was noted that in his thorough cross-examination of AR, one of the complainants, counsel for the applicant did not at any stage suggest that on her version of the events, her conduct, either in the course of the incident that was the basis of the charges against the applicant, or in the period between the date of that incident and when the police spoke to AR, in any way contradicted or militated against her account. She did not consent to being penetrated by the applicant. And the court went on to hold, this is at paragraph 62, so there was no issue in the trial and the evidence was wrongly led. So it's going to depend on the instructions, I would have thought, which of course get influenced by the overall circumstances of the matter. But there may be a different approach at different times to render this sort of evidence, or attempt to render the evidence anyway, irrelevant and therefore inadmissible. Having said that, getting back to this fine line, the legislature has said this evidence is admissible. So if it's kept to the generalised, it seems it's admissible. Whether in the circumstances of a particular trial a specific direction is required will depend on the particular trial. Any other questions, David?
This is more a practical question. When it becomes relevant, is it only going to be known by the prosecution, probably after the pre-recording, so once we've done examination? How does it all fit in a timeline, or how long is it going to take for a panel member to provide a report?
Well, how long it's going to take will depend on the individual expert, their work commitments and all those. But I don't agree that it's going to necessarily be an issue only after pre-recording. You can pick up your brief and see that there's been no complaint for 3 years and the complainant's been living in the same bedroom or same household. It's obviously a potential issue at that stage. I think that's our time.
I have an online question.
Yes.
It asks, do the new laws change whether a panel expert's own expertise can be challenged in the usual way?
No.
Thank you.
So challenge can certainly still occur. Just they haven't deemed any of the panel members to be unreproachable experts. So in the same way as any expert is ever engaged, their expertise is open to challenge. Chief Judge?
So the experts so far appointed as psychologists.
I'll let you take that one to get the details.
The legislation that says that is.
No, unlike Stream 1, which designated psychiatrists, neuropsychologists and psychologists and some other communications specialists, there was no perimeters around the expertise of experts for Stream 2.
Well, I think that question coming from the Chief Judge is a good segue to say, welcome the Chief Judge back to continue the other aspect of the presentation.